No copy.
Have you seen the order dated 14/3/2023? Answer.
He has prepared his answers.
Postal manual.
Yes, postal manual. A retired government employee can be appointed as an inquiry officer.
Huh?
A retired government employee can be appointed as an inquiry officer.
Where? Where is the provision?
1971 itself.
Huh?
1971 itself, the circular is attached in the last page. And second question was whether the upper limit was fixed and fixed.
No, where is this first? The retired officials can be appointed.
यस सर लास्ट आर्टिकल 4 के बाद लगा हुआ है सर सबसे लास्ट है सर राइट सर वही है
But under Rule 14(2), there is no provision.
No, sir. This is, sir, Government of India instruction, sir.
So instruction can override Rule 14(2).
Yes, sir. Not
Yes, sir.
14.2, no, sir. That is.
Sir, under Rule 14(2), appointment of inquiring officer is there.
Sir. Yes, sir.
There is no retired officer.
Yes, sir. Actually, sir, burden को कम करने के लिए हुआ है कि काफी.
Objective may be correct, but at the same time there is no amendment to the rules.
Sir, actually, this is the Xerox copy of CCA rule, sir. दिखाता हूँ 18 में है
Central. CCA. Page 87, 84 is possible.
Terms and conditions for appointing of retired.
Only date 61. It is of 16th February 1961.
Terms and conditions for appointment of
Retired officer as inquiry officer. The retired government, however, referred as an inquiry officer. 59/12.
Retired employee is not an authority. Under sub-rule 2 of Rule 14, authority is required to be appointed as an inquiring officer. CCA rule book है?
Yes, sir.
Read sub-rule 2.
59 page 59 है इसमें सर GID instruction है 12 terms and conditions for appointing.
We have to go by rule, not instruction. When a particular field is occupied by rules.
Sir, subsidiary Government of India instructions.
That is the reason we are asking you. That is the reason we are asking you whether instruction overrides rules. Which will prevail? Rules will prevail. So rule says that authority.
the explanation 2, where the disciplinary authority appoints a retired government servant as inquiry authority, but sub rule 7 to sub rule.
Which rule you are reading?
I'm reading or part 14, explanation 2 minute,
Ah.
where the disciplinary authority appoints a retired government servant as an
Huh?
explanation 2.
There is no such a thing in our book.
Not part 14, page 38.
Rule 14.
Yes, madam.
Ah.
Explanation.
Sub rule 1 and 2.
Yes, madam.
And thereafter provided.
Provided.
Next.
And thereafter explanation 1 and explanation 2.
Ah.
I'm reading explanation 2, where the disciplinary
There
authority.
is no explanation 2, 1, 2 and all. What is the date of initiation of inquiry? Second inquiry.
Second, 21/12/2001.
21.
12/2001.
Second child. The appointment of inquiry retired 16/5/2002. As on that day, this is not existing. This was incorporated in 2011, 5th December 2011. This is not applicable. Read. Explanation 1 and 2 has been incorporated for the first time on in the year 2011. Got it?
Yes, ma'am.
Then how are you relying on that? That is not applicable to the case in hand. कोर्ट मास्टर
Section
नया बुक लाने को बोला.
नया बुक लाइब्रेरी
56, 57. And I'm saying.
Yeah.
59.
Then on the last I can rely upon the circular which was issued case 59.
Circular will not override sub rule 2 of rule 14. Then the government of India realized that there is an amendment is required. Such amendment has been carried out in the year 2011.
Sir, the order is September 99.
No,
Yes, sir.
not order of appointment of
Again, it has been reiterated in
by 2009.
2003.
by 2002 is the appointment of retired inquiring officer.
Order was 1999. 1999. And I have also bring the recent circular, sir, in which Ministry of Public Advance has reiterated in 202.
No, what is this?
ये वो जो circular हुआ है ना,
Again, you are showing the circular.
22 अभी रिसेंट में एक्चुअली सर टाइम टू टाइम इंस्ट्रक्शन इशू होते रहता ये 20-22
No, no. We are bound by rules. These are all subsequent 2015.
यस सर
We are concerned with 2009.
नो सर सर ओरिजिनल ऑर्डर वाज 1999 सर and after that you are rated in 203 again 20
Sir, show me amendment of retired officials could be appointed as inquiring officer
Yes.
prior to 16/5/2002.
यस सर
Show us 16/5/2002. इससे पहले
1999 में है सर
हाँ
1999 में है सर
Sir, rule is not there. Instruction cannot be. How many times you want us to repeat? Do you understand? Instruction will not override rules. Rules will prevail.
अब दूसरी बात upper limit.
Petitioner has retired now.
Yes, my lord. Yes. Postal assistant, Lord, criminal case, my lords had asked me to get the judgment passed by my lords, where my lords had also, this January issue, it has been reported. 170. That where criminal case, more or less, same charges. That because of the delay, class 4 employee, sufficient pain. Here also, my lord, in the criminal case, he was acquitted, and thereafter this second charge memo has been issued.
See the paragraph?
Lord, in the first paragraph, my lords notice that criminal proceeding was concluded in acquittal. On the other hand, in the supreme proceeding, it concluded in imposition of penalty. And thereafter, my lords have held paragraph 7.
What is the page number?
Page 171.
LP 837 of 2020.
837 or 2.
they are very
This also, my lord, my lords noticing the pain undergone, sufficient pain undergone in parallel proceeding.
दो हजार चार में है ना
Third भाई explanation नहीं
Here also, but acquittal was in the criminal case was made on 20th December 2000. Then second charge memo 21/12/2001. And then this retired person conducted the inquiry.
2009
At that time, my lord, there were
is not accepted. अब आप second
There is the 18/12/2001 cancellation of charge memo.
that is not only
10,000 5,000
You are not produced.
That cancellation order is not on record. In the fresh charge memo annexure 2 at page 28, the first line is the memorandum issued under memo of even number dated 16/12/99 was cancelled on 18/12/2001. A fresh memorandum be read as follows.
So on what ground you are challenging?
Three grounds. Number one, the Shri B.N. Singh, retired senior superintendent of post office, was appointed as inquiry officer. That is apparent from page 83, not denied, second paragraph. Number one, it was not permissible in terms of 14.2 as it existed then. Number two, in the inquiry report, the inquiry officer opined that insofar as the question of theft is concerned and who's responsible for it, it is to be investigated by the police. Hence, this charge can safely be said as not proved. Despite that, my lord, order of removal was passed. Then the appellate authority remanded the matter to the disciplinary authority that you have to give reasons if you disagree. And what has been, what the inquiry officer yes, my lord, he disagreed but did not give reasons of disagreement. Kindly see annexure 5 at page.
Then after a disagreement, has he issued notice?
Yes, my lord. Notice was issued.
What is the date of issuance of notice?
Lord, 10/6. This is the 10/6/2004.
Where is the disciplinary authority's orders?
Lord, annexure 5 at page 87.
Please.
87. Page 88. sorry. Yes, this typed copy as well. Para 8, the undersigned does not agree with finding of IO because if Sri Ramdev Prasad was not given keys, then next senior most PA should have been made just custodian. Para 9b, the loss of 2 lakhs was sustained to the government on 10/4/99, and the said Sri Gopal Kumar Pandey is responsible for the said loss to the government had he not kept cash beyond limits. Government
Okay, page 84 or 88?
88,
80?
88, 88. At page 89, he says that give your reply within 10 days. Then specific reply was given that no reasons for disagreement are being given. In Annexure 6 at page 90. That copy of the said inquiry report of the IO was received earlier also by me with your letter so and so, without any view of your disagreement with the findings of the IO. Then he again passes the order.
No, page 88 is Shokas.
Yes, my lord. He gives
Where is the penalty order, termination?
the termination order is Annexure 7 at page 97, 17/11/2004. And he himself mentions at page 99 about 3 or 4, 8, 9 that B.N. Singh, retired SSPO, was appointed as IU. And he also notices the contention of the petitioner at page 100, last paragraph. He further stated that he is not able to submit a proper representation on the point of 3 disagreements of the undersigned, as no reason is given nor there is any finding from the undersigned. He notices that and still my lord does not.
अभी तो इससे से निकालना होगा
दोनों शटवा दी
चला गया
Second show cause reply before the disciplinary authority, this point was also taken, that no reasons for disagreement have been forthcoming.
तरह 2004 का ऑर्डर है डिसिप्लिनरी अथॉरिटी का
17/11/2004.
अपील में तो है 97 to 101 अपील पनिशमेंट और
Appointment of inquiry. You have a copy of cancellation of first charge memo, 18/2001.
That copies for the present is
No, why you people don't come up with a complete record? Is it not a departmental inquiry? Huh? Everything is in your mind.
पहला जो चार्ज मेमो कैंसिल हुआ है इंक्वायरी रिपोर्ट मांगने से मेरे पास था नहीं 2 बार प्रीवियस में मिला था
Sir, as a result, order of the CAT dated 14/9/2016 passed in OA 776 of 2005. CAT, Patna means for short CAT. The petitioner was appointed as a extra departmental staff on 31/1979. He has earned promotion to the post of postman on 13/12/1990. Further, he was promoted to the post of postal assistant on the month of December 1997. When he was working at Kusrupuru Post Office, theft of money had taken place. In this connection, he was arrested on 12/4/1999 and a case was registered in the police station, Kusrupur police station, case number 34 of 1999. Consequently, he was placed under suspension on 13/4/1999. He was subjected to disciplinary proceedings on 16/12/1999. To that effect, a charge memo was issued under Rule CCA, 1965, for short Rules 1965. During pendency of the disciplinary proceedings, he was acquitted in the criminal case on 20th December 2000.
started
The
after
suspension was revoked on 5/3/2001 and he was reinstated as a postal assistant in Patna city. The disciplinary authority proceeded to appoint an inquiring officer, namely Sri B.N. Singh, retired SDPO, on 18/10/2001. On 18/12/2001, charge memo dated 16/12/1999 was cancelled without assigning any reason. So also reserving liberty to the disciplinary authority to initiate a fresh inquiry. When things stood thus, on 21/12/2001, fresh charge memo was issued consisting of 4 articles of charges. Gist of the charge memo are that while he was working as a sub postmaster, Kusrupur Post Office, he had permitted sub postmaster Sri Sundar Ram to remain absent from duty during the intervening period from 8/4/1999 to 10/4/1999. Failure to keep cash balance in proper manner, and theft of cash balance was on 16/5/2002. BN Singh, retired SSPO, was once again appointed as an inquiry officer pursuant to the issuance of a fresh charge memo dated 21/12/2001. So the inquiring officer submitted his report. The DCP authority disagreed with the inquiring officer's finding, proceed to issue show cause notice. Thereafter, DCP authority proceeded to impose penalty of removal from service on 2/8/2003. Feeling aggrieved and dissatisfied with the order of removal from service, petitioner preferred appeal before the appellate authority, and it was set aside on 26/4/2004. And remanded the matter to the DCP authority. A communication was made on 10/6/2004 to the extent that DCP authority disagreed with the inquiring officer's finding. Further, show cause notice was issued on 12/7/2004. Thereafter, his services were terminated on 10/17/11/2004. Feeling aggrieved by the termination order, petitioner preferred appeal before the appellate authority, and it was rejected on 29/9/2006. Consequently, petitioner preferred OA number 776 of 2005. How can it be 2005 in respect of 2006 order?
I'm sorry. Lord, he had preferred an appeal and subsequently when the appellate order was passed, that was brought on record. I was just, he had preferred the,
The original application 2005, you are not challenging the termination order.
Lord, the termination order had been challenged and thereafter during the pendency,
OA number 776 of 2005. The OA is stated to have been filed during pendency of the appeal before the appellate authority insofar as challenging the order of termination dated 10/17 November 2002.
OA was filed, and since the appeal was not being disposed of, it was disposed of during the pendency of the OA, which was challenged by filing an amendment petition. And therefore, both
By
the,
interlocutory application, you have challenged the appellate authority order.
yes, my lord, before the CAT.
But the CAT rejected the original application
First,
Lord,
776 of 2005 and 14/9/2016.
CAT allowed it.
Allowed.
Yes.
Then why you have
Union of India came to the High Court.
huh?
Union of India
came in the
thereafter
High
came to the High Court.
and the writ allowed on 21/4/2015.
That details are not available.
Yes, my lord, I've given list of dates.
131 minutes.
OA 776 of allowed and remanded the matter.
Yes, my lord.
That was the subject matter of CWGC.
Yes, ma'am.
33.
Yes.
OA 776 of 2005 was allowed in part. However, Respondent Union of India preferred CWGC 3133 of 2010, and the matter was remanded to the tribunal. Thus, the tribunal decided that OA number 776 of 2005 afresh on 14/9/2016. Hence, the present writ petition by the petitioner. Well, on counsel for the petitioner submitted that in appointing a retired official as an inquiring officer is contrary to sub rule 2 of rule 14 of CCA rules 1965. It is further submitted that inquiring authority, the inquiring officer, held that charge in respect of theft is concerned was not proved. The same was disagreed by the disciplinary authority. However, the reasons are not supported insofar as the disagreement only on presumption. Disciplinary authority proceeded to disagree with the inquiring officer's report. It is also submitted that appellate authority has not considered the petitioner's appeal, memorandum of appeal. In one line, the appellate authority has stated that memorandum of appeal is sketchy. So, per contrast, for the respondent, the CAT has not appreciated the legal issue that a retired officer has been appointed as an inquiring officer, and it is contrary to sub rule 2 of rule 14 of CCA rules 1965. Therefore, order of the tribunal is liable to be set aside, and thereafter orders of the disciplinary authority and appellate authority order are liable to be set aside. And the petitioner is entitled to consequential monetary benefits from the date of termination till the attainment of age of determination. Control and counsel for the respondent resisted the aforesaid contentions and submitted that the retired official can be appointed as an inquiring officer in the right of CCA. In the light of the light of
59.
explanation 2 sub rule 2 of rule 14 of CCA rules. Sub Therefore, there is no infirmity. It is further submitted that having regard to the charge, there is no infirmity in the inquiry proceedings. So it is submitted that earlier also this court has remanded the matter to the tribunal. Respondents have supported the order of the CAT, heard the learned counsels for the respective parties. Factual aspects are not disputed. Full stop. One of the legal contention raised by the petitioner is that appointment of a retired official as an inquiring officer is contrary to sub rule 2 of rule 14. It is further submitted that disagreeing with the inquiring officer so far as alleged theft of money from the office of the sub post office is a serious charge which is required to be proved in the manner known to the law. Merely disagreeing with the inquiring officer's report and proceeded to issue show cause notice that does not suffice to prove such a serious charge. The aforesaid contentions were required to be examined in the light of sub rule 14.2 unamended sub rule 14.2 of CCA rules. Prior to 5th December 2011, the explanation number 1 and 2 to sub rule 2 of rule 14 of CCA rules 1965 was not existing, so as to give effect to explanation number 2 first up. It is necessary to reproduce the extract of rule 14 within rule 14 within bracket 1, again within bracket 2, which reads as under. First up, perusal of the explanation 1 and 2 to sub rule 2 of rule 14 of CCA rules, it is crystal clear. For the first time, it was incorporated in the rules on 5/12/2011, whereas the order of appointment of inquiring officer in the present case is 18/10/2001. Therefore, amended rule cannot be given effect to so as to apprise the fact that a retired official could be appointed as an inquiring officer. On this legal issue, the petitioner has made out a case. Further, it is noticed from the records. Charge memo was initially issued on 16/12/1999. It was abruptly cancelled on 18/12/2001 without reserving the right of liberty to initiate a fresh inquiry by the disciplinary authority. In such an event, perusal of the various provisions of CCA rules, disciplinary authority is not empowered to initiate fresh inquiry in the absence of judicial order or reserving right for himself for issuance of a fresh tariff. Even on this count, the petitioner has made out a case. So these material information have not been apprised by the CAT while passing order on so and so in OL number so and so. In view of these facts and circumstances, the petitioner has made out a prima facie case so as to interfere with the order of termination dated 10/17/11/2004, apparent authority's order dated 29/9/2006, and order of the CAT dated 14/9/776 of 2005, and they are set aside to submit. The concerned respondent hereby directed to settle the petitioner's monetary benefits from the date of termination till the date of the retirement. Such calculation shall be made disbursed in favor of the petitioner within a period of 4 months from the date of receipt of this order. Written.
6 months time may be granted for implementing. 6 months time be granted to implement.
Why 6 months, sir? कितना टाइम लगेगा कैलकुलेशन करने के लिए?
It will take some time to tell them. I pray for 6 months time.
This is our direction. You comply.
The heading for admission serial number 10 and yes, no construction versus the state of Bihar for the research being Kali Prasad Dubey.